present a number of people I may not be acquainted with, so let's see here. It's Mr. Workman? That's you. Okay. Good morning to you, sir. Represented by counsel, Mr. Wilson.
Yes, sir.
Okay. Good morning to you both. And then is it Mr. Golston?
Golston.
Okay, with counsel, Miss
Carrie Lynn Crafthopper.
Okay, Ms. Crafthopper, nice to meet you. Good morning to you both.
And then we also do have Mr. Anderson here.
Mr. Anderson, okay, good morning, sir. Mr. Bannock appears for the Champaign County Clerk, who is sued for relief purposes only in the administrative review. Good morning, Mr. Bannock.
Morning.
Okay, and Mr. Wessner
Yes, Your Honor.
appears for the village. Okay, counsel and Mr. Wessner, the first thing I want to do, let me start here. Have I missed anybody who intends to enter an appearance today? No. Okay, good. We're done with appearances. The next thing we need to take up, Mr. Wessner, unfortunately I'm afraid I'm going to have to pick on you a little bit. I imposed a very tight timeline, owing obviously to the exigency of the matter. But we do need an actual recording filed, so I got your
Not the link. Okay.
I got your link,
Yeah.
and I have a couple comments about the state of the record. First, we're going to need an actual recording placed in the court file. The transcript is best.
Okay.
If we have a transcript, we want the transcript. If we don't have a transcript, then we need the actual recording in hard copy, and then that could be tendered by disc or file dropped on a USB,
Certainly.
but it'll need to be left with the court. And then I saw Mr. Wessner, it looked like the record was filed. There were several different submissions. I think in order to have the record presented in some way we can refer to, we're going to need to have it submitted as one document with consistent pagination.
Yeah, I apologize. And Ms. Crafthopper kind of pointed that out to me too, and kind of relayed to her, and I will obviously manage to try and figure this out. Is my equipment, I don't know if my scanner handles over 100 pages, trying to get it all in as a single document, so I'll find means to be able to do that, as well as try and paginate through the entire document in terms of one to whatever the file number is. So.
Okay, and that'll make clear how we can refer to documents in the record. For the purposes of this hearing, if we're going to refer to a document from the record, we need to refer to the title of the document and then be clear about what document we are referring to, so that we preserve an accurate record for the appellate court. Okay, Mr. Wessner, I'm done picking on you.
I knew this was coming, Your Honor. It's okay. I get it, as I shared with counsel, and I think the court too. I was in a rush trying to respect everybody's time too, and trying to figure out, just getting in and hoping to line it out in a way that would be helpful in terms of preparation for today.
Okay, thank you, Mr. Wessner, and thanks for being a good sport. Okay, next, we've dealt with the record. I'll tell the parties and anybody else who's present how we're going to proceed today. We'll start in the following way. First, today will be sort of an anticlimax. I intend to rule in writing to resolve this dispute, so there's not going to be a dramatic moment at the conclusion of the argument where I declare what the law is. I will try to rule by the end of the day tomorrow in writing. I thank the parties for their written submissions. I thank them for complying with what I will characterize as a very tight briefing schedule. And I really do appreciate the written comments of both sides. In this matter, I had an opportunity to review them last night and have begun working and doing my own research on this as well. So, okay, we will, at the conclusion of the hearing then, I'm telling you what's going to happen from the outset. I'm going to take the matter under advisement and try to rule by the end of the day tomorrow. Okay, then, here's how we'll proceed. Ms. Crafthopper?
Yes, sir.
Okay, and I'm sorry. I haven't had you practice in front of me before. There we go. I've written it out phonetically for myself. I'm going to have you start. You're the petitioner seeking administrative review. Then, Mr. Wilson, I'll give you an opportunity to respond to her arguments. I'll give you the last word. Unfortunately, I'm going to have questions for both of you. I will try to insert the question into your argument so you can address it at an appropriate point in time. I'll try not to be too disruptive with the interruptions, but I'm afraid that's probably inevitable. So don't take offense. I mean no harm. Just trying to get the questions answered at the right point in time in your arguments. So, with that in mind, Ms. Kraftheffer, I have read your submission. What do you want to tell me about your position in this case?
Actually, Your Honor, before we get to that, there's one other matter of housekeeping I think we should handle related to the record, which is that one of the filings in this matter that we received over the past couple of days, it's entitled Answer in Response to Objector's Petition for Judicial Review of an Electoral Board Decision, and there's no party attributed to it. So I just think for the record, we should clarify which party is filed at, because it's not referred to anywhere in the pleading.
You're talking about the document filed yesterday?
Yeah, yes, it says it was prepared by Mr. Wilson, but there's nothing in it that says who, like on whose behalf. So I think just to keep the record clear, we should articulate that while we're here.
Okay. Mr. Wilson, you entered your appearance in this case
For Mr. Workman.
for Mr. Workman.
And this was intended to be filed on his behalf, Your Honor.
Okay.
So, mea culpa.
Okay, we'll just amend the document on its face. Thanks for pointing that out. But it is clear, I think, from the entry of appearance, Mr. Wilson did intend to file this on behalf of the question proponent, Mr. Workman. And this is a little unusual because often we're dealing with two different contestants in an election, not the proponent of a question and an objector to the question. So it's a little strange procedurally. So we will note that the answer in response to objector's petition for judicial review of an electoral board decision has been filed by Mr. Wilson on behalf of Mr. Workman, the question proponent. All right, thank you. And thank you, Ms. Kraftheffer, for bringing that to my attention. Okay. Anything else you believe we need to take up before you begin your argument on the merits?
I think that was the only housekeeping matter. So this issue is really a strict statutory issue, and that involves an interpretation of section 3.1-25-85 of the Illinois Municipal Code, which permits any municipality that is operated for more than 4 years under the provisions of the municipal code that allow the establishment of municipal districts for representation to abandon that form of government. And the question really is presented is, has the Village of Rantoul operated under the district representative form of government for 4 years, and did they at the time this petition was filed? So that involves us actually taking a look at a couple other statutes and then applying the facts of the situation here. So when we look at how Rantoul originally adopted the structure under 3.1-25-80, it's important to look at the language of that statute, because what that statute says is that if you want to establish these representative districts, quote, the Board of Trustees shall proceed to district the village, and the election of trustees for the village thereafter shall be in accordance with yet another provision of the municipal code. So what's important about that statute is that it's not self-executing. So it doesn't say, for example, immediately upon the occurrence of the election, this will happen. It says that if it happens, there are additional steps that have to be taken. And one is that the Board of Trustees has to district the village, and then thereafter, there actually has to be an election. Now, the other thing that is critical in the statute is under section 3.1-25-17, there's a sentence that says this redistricting shall not be completed, or shall be completed, not less than 30 days before the first day for the filing of nomination papers for the next succeeding election of the village officers held in accordance with the general election law. Now, the reason that sentence is important when we talk about how long has Rantoul been operating under this form of government is that it shows us when the redistricting has to be completed, or at least shows us the recipe for applying the facts to that situation. Now, in Rantoul, the electors decided they wanted to go to the system under 3.1-25-80 on November 6th, 2018. So that was the election date. That triggered the requirement that the village board then had to do an ordinance to actually district the municipality. And the village board did that on June 9th, 2020. Then, in addition, there then was an election thereafter that voters were elected per district. And it's our position that until there were districts and until there were people elected into those districts, the village cannot have been operating under that
In your
form of
brief,
government.
it also states until they were sworn, which is the election, consolidated election was in April, and then the actual initiation of the term was May 4. Correct?
That's true, because ever since the Bush versus Gore decision, Illinois amended its election code so that now we have provisional votes counted and the election results aren't even certified until after the election date.
Okay. Can we stop here for a question, please? So when we think about timing, if you're going to propose a question to abolish this form of government, and you want to go about calculating exactly when to do that, I understand the statutory arguments you're making, but one of the arguments that I'm characterizing here, that the question proponent and respondent makes is, and again, I'll give you an opportunity to quarrel with my characterization of your position. It's sort of an Occam's razor position. In other words, this is very hard to determine when all the provisions are in operation. There's no clear statutory date that says it must be in operation by this date, as it would in a self-executing statute like the one in Dedonker. But why isn't the answer, most people would understand, we voted to adopt this form of government, and then 4 years later we want to vote to get rid of this form of government. Why isn't the simplest explanation of how to calculate the 4-year term the one that should prevail when we're dealing with asking voters what they want? Why shouldn't we use the simpler calculation?
Well, actually, I would say there's two answers to that question. First is when you look at the direct language of section 75 that I just referred to, it says that the districting has to be completed by a certain time. So you can't operate under a system of government before the districting has occurred. But second, this is a case of first impression. So we don't have any court guidance on this particular statute. But we do have the court cases that have previously been cited, and the question that you're asking was the same question that was posed in the Mason case, which is, why can't the process be started to get it on the ballot later so that by the time of the election the 4 years has transpired? And I think therefore the court's reasoning in that case is really applicable here. And that court said, well, you have to look at the legislative intent, and the legislative intent is that the voters would have operated under that system with a sufficient amount of time for them to determine whether or not it was really working for them. And if you have, as you have here, a situation where this was just implemented and within the past 20 months, we haven't even lived with it for 4 years yet, the legislative intent isn't satisfied. So we think that the statutory language, while it doesn't directly say this is when the date is, that when you compile the fact that it does state that the redistricting has to occur and be completed by a certain time, and then thereafter you have to fill the provisions with elected officials, you can't have operated under that structure prior to that. And then,
Let me ask you another question. It doesn't say operate under the statute. It says operate under the provisions. Right? Why, you're reading in, when it says provisions, the assumption, as I understand it in your briefing, is that means all provisions. All provisions must be complied with in order for the sense is, as long as we start the process, we're operating under a provision, or maybe a provisions would be more than one provision, not all provisions. Why can't we read it as some provisions we're operating under?
Well, one of the rules of statutory construction is that when you're looking at a statute, the best indication of statutory language and of legislative intent is actually what the statute says. And here, 3.1-25-85 doesn't say under any provision or a provision or started the provisions. It says under the provisions. So because it's referred to in the plural in the statute, it doesn't state that the process has to be started, and that assumes all of them will be completed. And as we also mentioned in our brief, one of the members of the Electoral Board pointed out that you can't operate a form of government without having the people in there to actually do that. And it's interesting when you kind of look at the history of how this law has developed in the other cases which involve the manager statute. While that case from 1959, the language of the manager statute at the time said that it became effective immediately, the General Assembly subsequently, 40 years later, amended even that statute to say that it would be upon the time that a municipal manager was actually appointed. So that kind of also shows that at least the legislative intent in correcting that statute was trying to set a timeline for that manager body of law, even though that's a different body of law. So it's more of an analogy. So I also believe that the Dodonker case is not inconsistent with our position here, because the language in that managerial statute at the time that the appellate court found compelling was the language that the board was immediately directed to issue a proclamation declaring the article in force. We don't have that kind of language in this statutory scheme. Instead, we do have an entire process that has to be followed.
That's what you've referred to as the self-executing portion of the statute.
Yes, sir.
Okay.
Yes. And Rantoul did embark upon the course that it was supposed to at the time. But other than that, the respondents hadn't raised, and nor did the Electoral Board actually articulate in its decision, any kind of basis as to why that timeline would be applicable here. There's not any factual findings that the Electoral Board made in its written decision. There's not any analysis of why they found the way that they did. And when they deliberated, they made some comments, but they didn't specifically say why they were finding when the starting date was when it was. So we believe that if we just apply the language of the statute, the outcome would be that you have to have operated under the provisions, which would mean all of the provisions, which means you can't do that until you have the people in place and when they're installed in office, and that there's not a factual dispute, really, that this did not occur within 4 years of that timeline, if that's the clock that we're using. There is another issue, though, that's raised in the brief that I just wanted to touch on because it's out there, and it's an argument that we did not file a proof of service related, I think what they're claiming, is to a person who's named in the heading of the original objector's petition, who's Sherry Johnson. And I just wanted to address that issue for the record. First of all, we did file proof of services.
Before you do, was that raised in front of the board?
It was not argued in front of the board, but if you look at the pleading that was submitted as a part of the objector's argument, there are words that could be construed to have raised that argument, and because it is raised here, I just wanted to briefly address it.
Go ahead.
So, and like I said, it's not exactly clear what that argument is, but it was related to the proof of service. We did file proof of services in this case within the statutory time period for all the members or all the parties that are required to have service under Section 10-10.1 of the Election Code, and that would be the Electoral Board members and the parties to the proceeding. Now, from the record, when the petition was filed, they did not file a certificate indicating who the primary proponent was for purposes of Article 28 of the Election Code, but Mr. Workman did come up here and advocate the position on behalf of the parties, and there were also comments made by the municipal clerk at the beginning of the Electoral Board hearing that she received the petition from Mr. Workman. So we believe he was the principal proponent, the proper party for service. He was named in this, he was served. We also named the Champaign County Clerk because that's the party that would configure the ballot. And we did name all of the members of the Electoral Board as well as the Electoral Board itself, which is the requirement of the statute.
You're talking about in your petition for judicial review
Yes,
to
and
vest the court with jurisdiction, right?
yes, sir.
Under Chapter 10.
In addition, in subparagraph F of the Electoral Board's decision, they did find that they had jurisdiction. And I don't believe that there's any legal basis for a claim that because Ms. Johnson was named in the title of the original objector's petition that she's either a necessary party or a party entitled to service under section 10-10.1. We would argue that to the extent that was kind of briefly commented on, it was not really fully argued before the Electoral Board, and the Electoral Board did find that they have jurisdiction. I just wanted to make that argument for the record.
Okay, thank you.
So for those reasons, we believe that the Electoral Board's decision should be reversed.
Okay, thank you very much, Ms. Krafteffer and Mr. Wilson. Now is your time. If you want to respond to anything she has said, go ahead and then tell me what you want me to know, in addition to what you've written.
As I understand it, what council is arguing essentially is that the village blew it. They were required after the election, within 30 days to district. They didn't do it. I think it was almost a couple years later before they managed to reach an agreement as to redistricting. So the question then becomes, are we properly redistricted now? Or did we lose that opportunity? Did we waive it? Are we barred from operating under the Alderman division of 6 population districts in the village? I don't know that answer, but it seems to me like it's a logical sequel. If you don't follow the statute, you can't pick up your marbles later and say, okay, now we'll play. And then say, oh, and we get a break because you can't object to this form of government because we didn't do our job.
Mr. Wilson, arguing down that line, one of the cases actually decided by the parties, I think Mr. Donker, deals with a mandamus action, but there was no mandamus action filed at any time to compel Rantoul to draw the districts. Is that correct?
As I understand it, that's correct.
Okay, all right, go ahead.
And we look at the Danker decision, I think that tells it all. Because that, of course, was not mentioned in the objector's initial case. They just wanted to go on the Mason decision, which said, oh, you didn't file within the appropriate time limit, so we're throwing it out. And I was just amazed when I compared that decision with the decision in the Donker, because it's the same justices that decided this.
It's actually out of the same county within 3 years.
And I was just amazed by that, quite frankly, because I thought, I wonder who the justices were that contributed to those 2 decisions. So, in any event, I think the Donker throws out Mason to the extent it's inconsistent. And the Donker, for the first time, said, okay, this time starts running on the election. And I think that's prudent to follow because essentially that means we don't care if the municipality is going to drag their feet. This is what the electors said. We follow the voice of the people. And that starts it running because technically that's the operating date and that's what the Donker said. If the legislature didn't like that, they could have changed that statute. They didn't do that. And so consequently, I think the Donker is binding on us. Now, as I admitted in my pleadings or my argument that the Donker was a managerial system as opposed to trustees and an alderman district thing. And so I think at that point, there is some difference, but we can look at a decision in the Donker which specifically found a start date. And it was not upon the whimsy of the village getting around to actually redistricting. So I think that the Donker is controlling at that point, and it The date is the date of the election.
Let's put that to one side for just a moment. We'll return to it. But doesn't the Dunker say that the petition can't start circulating? All provisions are in force here, and the petitions can't start circulating within the 4 years. I believe it states that in the Dunker.
Actually, I can at least tell the court that Mr. Workman talked to the Board of Elections in Springfield, and they said you could start at any time.
Well, what someone said in Springfield is certainly not controlling, thank goodness, upon the court.
But that was the document.
Unless that person is the General Assembly, and we have a vote and it's enacted. But what people at the Board of Elections say is not binding upon the court. What this case says, the case you're citing, says that the petitions can't start circulating. And do you agree that the petitions began circulating in September of 22?
I don't have any specific recollection, but
It's a couple months later.
I think Mr. Workman's saying it was a couple months later than that.
That's not in the record.
Well,
The only thing that's in the record is the petition itself, which says it was circulated between, and I have a beginning date and an end date, which is proper, and there's no objection there was no objection to the proponent's question based on improper circulation. The circulation appears to have been proper, that's not before me. The issue is reading the Dunker and taking the then second district at its word, that puts the beginning of circulation date inside of the 4 years, does it not? Because we're moving from November 6th of 2018, and then you would have to count out 4 years to November 6th of 2022. If the petitions began circulating in September of 2022 and concluded circulating in December, then they would have begun, unless they began on November 7th and stated so, which they don't. That would be within 4 years, right?
That's correct. If the 4 year is applicable to the starting of petitions like Mason said, that's not what the Dunker said. And the other thing is, I don't know quite.
That is what the Dunker says about the starting of the petition, right? The part of the Dunker that you're focused upon is what she calls, Ms. Krafteffer calls, the self-executing part. In other words, it's approved by the voters. There's a provision in the statute that says the proclamation shall issue declaring we are now operating under this form of government. This would be a lot easier if the statute had said to do that or not do that. I would argue we are in a more difficult position than the court was in the Dunker.
We're in a very difficult position, yes. I would concur with that, Judge, but I would have to look and see when the dates of signatures were put on the
Well, that's part of the record. It just says, I can tell you that, the signatures are not individually dated. The petition itself says circulated between September and December. Forgive me, I don't know the exact dates.
Well, I don't know it either, Judge, to be quite honest. Do I think that's appropriate? No, I think what Mason did was basically say that the petitions can't be started before that 4 year period. But I didn't think the Dunker said that. And that takes us to something I addressed later in the argument, and that is, this is not the village doing this. This is individuals doing it. Citizens.
Hold on, I want to clarify this point. This is from the Dunker. None of the various steps in that series of acts, including the petition to abandon, may precede the expiration of a 4 year time period. It says 4 year period of time. I'm sorry, I transposed the words. I'm reading that from the Dunker.
Well, then I would say that we have to look at when they were turned into the village as opposed to when they were acquired by the persons who are passing the petitions out. Because at that point, you get into the question about acquired, and I'm not sure what that phrase means. It's another question of fact.
stop there for just a moment. I apologize. The objectors and petitioners for review believe that my review is de novo. What do you believe the standard of review for me is?
I think we were bound by the decision of the board that it's a mixed question of law and fact.
So the clearly erroneous standard.
Correct.
Okay.
And what, do you want me to just stop there? Or?
No, keep going. I'm curious about this.
The reason I say that is that gets us into the abandonment. What is abandonment? Once again, the legislature provides no guidance about what abandonment is, and it's particularly, if you will, screwy in this case, because we're not looking at the mayoral sort of thing. We're looking at something where even if this is on the ballot, and even if it passes, part of the ballot is going to include the election of 2 or 3 new trustees. I think it's 3. And they will come in under the Alderman 6th District provisions. And we don't, with the abandonment, if you will, I don't think that we're entitled, pursuant to the statute involved, to throw all the trustees out and start new. I think those people, and the Attorney General's opinion that we cited is right on point, I think. If we were to do that, we would be facing some dire constitutional consequences. But
Dire, D-I-R-E, not D-Y-E-R.
D-I-R-E, yes.
Go ahead.
We're waiting for those consequences too, Judge, but other than that, I think that whoever is elected this April is entitled to their terms. The people who are not up for re-election, they're entitled to complete their terms. I think that's what the statute requires. I think that's what basically the Attorney General's opinion says is the thing. Now, does that mean everybody is treated as trustees at large or per district? I don't know, but that's going far beyond what we're here about today.
Let me ask you a question about that. The appeal of your position is that it's, from my vantage point, is that it's simple. We're looking from one date where voters do something. We clearly know what that date is. We can calculate it into the future. And then we're looking at another date when the proposition would be ratified. What happens in a situation where well, first, do you agree with that? That your calculation is from voter approval, qualified elector approval in a general election to qualified elector abandonment in an election. Do you agree with that characterization?
Yes.
Okay. Then, would you agree that in a case where, let's say, the voters approved something on November the 8th of one year, and then 4 years later, the election day was November the 2nd. Under your position, we would have to wait an additional couple years, correct?
I think that's right.
Okay.
You've got that 4-year period.
Right. So, from my vantage point, that cuts against one of the strengths of your position, which is that it's simple. Because even in that situation, it's not quite so simple as we're not dealing with electoral cycles. Perhaps that would have been the simplest way for the General Assembly to tell us what the law is. You have to go through however many elections, and once those elections have proceeded, then you can abandon. But what about this language from the second district of the late 1950s, finding a clear intent of the legislature that they wanted to make sure that people had enough time to observe whether the choice they had made was functioning, and then draw their conclusions after that system had functioned for 4 years as to whether they wanted to keep it. What do you say in response to that clear finding of legislative intent from 1957, but in a related statute?
pointing in the note here.
Take your time. It's okay.
Could I ask you to restate your question, please?
Sure. Let me just quote it to you. Yeah, this is Mason, so ILAP 2nd, 378 at 382. Furthermore, we see a plain legislative intent to provide a minimum trial period for city manager government. I understand this is a different statute, but the same architecture as our statute with a few alterations. To provide a minimum trial period for city manager government to operate free from the instability, unrest, and uncertainty that obviously would attend proceedings looking to its possible termination. It is more than a matter of the waste and expense of frequent elections, but involves the question of whether or not a form of municipal government adopted by the voters should be afforded the opportunity to function in a stable atmosphere such that the electorate can fairly determine whether it provides a form of government that is desirable to it. That's from Mason. And the objectors and petitioners in this action believe that DeDunker and Mason can be read harmoniously on that point. So what's your response to the 2nd District's finding of plain legislative intent?
Well, number one, I'm not sure what plain legislative intent ever is, but in this particular situation, I think the thrust of it is to have an opportunity to review the operation of government over a period of time. Now, we know that, if you take our position, that it started in November 6th or 8th, I think it was the 6th.
November 6th, 2018.
We've had that period of time of review of the situation. But, taking it a step further, so what? If this goes on the ballot, we are still operating under the district provision, and we will be for some period of time until everybody's finished their terms, their staggered terms. So it's going to be 2 or 4 years more of being able to observe them. And if they think it's a great thing and it is working well, which very few people think right now, then they can just put a ballot or a referendum out saying, okay, we want to have alderman districts again.
Well, okay, I understand that, but at least one way of reading the appellate decision in Mason is that that's exactly what the General Assembly is trying to avoid. This kind of overlapping cycle of we have adopted a new form of government, we elected the people, and then before they're even through their terms, we've proposed a question to abolish the whole system that they're under. And that's very unstable, and the General Assembly says they find legislative intent in the architecture of the statute to avoid that. I mean, if you think about it, if the trustees are sworn in in May, and they are not again, and then this question is proposed, just a few, in my notes. Right, the question is proposed in, the trustees are sworn in and begin serving in May. I mean, we're basically at 2 years when the question petitions begin circulating, right?
I think that's probably fair, but that's not what the law said. The law says it's being enacted in November 2018. This is the system now. If they dawdled at the village of Rantoul for 2 years to get those districts drawn,
Yeah, that is curious. There's no explanation for that in the record.
well, in the records, a good way to put it, Judge, but
That's all that I'm allowed to consider, Mr. Wilson.
the bottom line is, I don't think the legislature contemplated this dawdling and not moving within, I think it was, 30 days to have those districts run?
That's what the statute says.
They didn't do it. It should have been done. why is that any absolution for the objectors at this point to weigh out how the system looks like it's working?
Well, but play this out a little bit. Let's assume, counterfactually, that they had done that. That would, by my quick calculation here from the bench, that would have meant that the 4-year mark, let's say that was December that they drew the districts, and then the consolidated election was the following April. That would still put us under the 4-year time period, correct? Because we'd be seating people in, the districts were drawn in December. There can't be another election until the spring. So that's still under 4 years.
But that's rewarding the village of Rantoul for dawdling and not getting the districts drawn within 30 days of the election in November 6th of 2018.
No, what I'm saying, the hypothetical is, let's pretend they didn't do it. No question about that. Let's pretend that they did, okay? Pretend that they did everything right. We're still under 4 years from time of all provisions being in effect to petitions circulating.
If that's the date, it's about 2 months premature circulation of petitions.
Well, there's no, to my knowledge, Mr. Wilson, you can correct me if I'm wrong, there's no close enough savings clause in the compiled statutes. So many times I wish that there were. But in this case, it says 4 years. I have to assume the General Assembly meant 4 years. So in other words, I'm not trying to pick on you here. I'm just saying the argument that Rantoul screwed this up, even if they had done it right, almost all of the arguments that are being advanced by the objectors would still be valid in terms of the time.
Well, if the court would decide this based upon when the first signature went on a petition, that might be right. But I would have to review that and see, but I also don't know when it was actually submitted to the clerk of Rantoul.
Okay.
Once again, we kind of go back to the Mason sort of analysis that, to start the petition, you got to do it after 4 years. And I don't think that the Dunker cut him that kind of slack, but I understand the court said that it was feeling differently about that.
Well, they're just, I'm just not sure if I agree with your reading of the Dunker. The Dunker, the holding of the Dunker, I understand, is agreeable to you. But the question I have is the reasoning by which they arrive at the holding is predicated upon what she calls the self-executing, self-actualizing portion of that statute, which is not in front of us today. But the salient point is, they argue that the provision of the statute that says immediately after this question is adopted, there's a proclamation that issues, that means you're operating under it. That's very clear. That would make our job a lot easier if the statute says that. But that's the factual circumstance through which the reasoning passes in arriving at the holding. We don't have that circumstance here, which they argue is or should be dispositive. What's your response to that?
Well, my response to that is that the law is clear, and that is when the electorate passes judgment, that and the votes are counted, that's the dispositive date for operations.
Okay. All right, thank you. And is there anything else you want to tell me, Mr. Wilson, before I turn it back over to Ms. Crafton?
Well, one thing that wasn't mentioned is, and this is just came to my attention the other day, that is Sam Hall, one of the trustees, had signed the petition that Mr. Workman and his people were relying upon. And then he should have recused himself from the board, and he didn't do that.
Was that raised in front of the electoral board?
No, it was not. It wasn't raised because I don't think we figured it out other than seeing Sam Hall sitting there.
Okay. And I understand your point that, but can you identify any specific provisions saying that that's offensive to his role on the electoral
Well, I
board?
think we cited about 3 different cases, Judge.
Yeah.
Unfortunately, none of them were, I don't think, electoral cases.
Well, certainly, if that were a judge, they would have to recuse. I agree with you there.
Well, I didn't think the electoral board was, for all practical purposes, playing administrative judge.
Yeah, that's the strongest argument for you, for sure.
So, I mean, when I realized that, I was utterly aghast. But, oh well.
Okay. All right. Anything else then, Mr. Wilson?
On that particular point,
On any point you wish to
Oh,
raise? I apologize, I have a very bad habit of getting people distracted with what's concerning me. But is there anything else you wanted to tell me about your position?
well, I think we've raised it all in our argument, and I don't, other than the objectors and myself, I don't know if anyone else has filed an answer, and I thought everybody was ordered to do so. But in any event, I don't know what particular positions are for the state or the village. All right.
Okay. All right, thank you, Mr. Wilson. Ms. Kraft-Tepper, back to you. I want to start, I'll give you an opportunity to say everything you want to say, but one of Mr. Wilson's points is that we have not given sufficient attention to the term abandoned. That the Mason and the Donker case do not turn on that word, but our case should turn on that word. What's your response to that argument?
It would really be the same as the original arguments here, that you would not abandon that form until the municipality has implemented whatever the statute requires to do that. It's not abandoned on the date of the election. There's nothing that says that. Election results aren't even effective on the day of the election. So there's nothing in the statute that says that this continues until it's abandoned.
Hold on just a second. Doesn't subsection 85, isn't that called abandonment? So wouldn't that be, if I were to try to make Mr. Wilson's argument here, I would say, accept that. That's the name and purpose of the statute. So it may abandon. And then it tells us under which provision we may do that. The petition is to abandon. The question is about abandoning. So why isn't the start date, if you will, for abandonment, the ratification of the proposal?
Because at the time the election would occur, you have elected officials in office that were elected by district. So you can't abandon a district representation form while you still have people elected by district. You would need to have an election replacing them with candidates elected by at large in order to abandon that. Now, that raises a separate issue about terms of elected officials, which people have kind of commented on. So generally, the law is that once you are an elected official, you have a protected property interest in holding that office for the term you were elected to, and there's also due process rights with that. However, the cases that have determined when can you remove elected official from office during their term of office have held that if that due process is satisfied by voters electing people or approving a referendum, or by the General Assembly changing statutes. That's what happened when they abolished that extra school district election we used to have. So so abandonment of that form of operation wouldn't occur until the next time there was an election. Because you have people, and actually that goes back to why the system that they're operating under is so important. Because how do you operate under a different form of government when you haven't elected people under that form of government, or under that system of elections? Maybe that's a better way to say it. But that's why the abandonment issue wasn't there, it wouldn't change the clock either way. Our position would be the same, even if we were just focusing on the abandonment issue.
Okay. And then responding to any other issue raised by Mr. Wilson you want to bring up?
I actually would like to dive into this 30-day issue, because I think there's some confusion about it. We are not claiming that the Village of Rantoul did something wrong or something too late, and I want to articulate that as a matter of the provisions of the election code. So the election where the voters passed the referendum initially was November 6, 2018. That was a general election. So under our election code, we have 4 different kinds of elections. We have general primaries, general elections, those occur in the even years. Then we have consolidated primaries and consolidated elections, which occur in the odd year. So November of 2018, Rantoul passes this election. The next election is going to be in April of 2019. But you have to look at what the statute says. It says that this redistricting
Which
shall...
statutory provision are you quoting from?
This is 3.1-25-75, sub A, the last part of that. This redistricting shall be completed not less than 30 days before the first day of filing of nomination periods for the next succeeding election of village officials. The problem is, by the time the vote results would have been satisfied under our election code, the way they have 28 days to count provisional votes, the November 6th election results wouldn't have had to have been certified until about 28 days after that. In the meantime, the circulation period for the April election and the filing of those petitions would have been in November or December, depending on whether or not you're filing as a candidate for a primary election or not. And what this says is the redistricting has to occur 30 days before the first day of filing, which actually would have been a couple of days after the November 6, 2018 election, and the vote results wouldn't have been satisfied by then. So what I'm saying is it was impossible for the Village of Rantoul to have satisfied that provision for the 2019 election. So the only election that they would have been able to do that for after the vote results were certified for 2018 would have been what they did.
Well, that's true of the election, but one of the arguments is if we're talking about our provisions complied with, the provision is not complied with, is what Mr. Wilson is saying. In other words, the clock's running regardless of when the next, it doesn't say in this statute when the next election is. The 30 days is untethered from that. That's his argument.
Okay, now I'm sure I understand that argument though, because it says it has to be completed 30 days before the first day of filing a nomination petition for the next election. It does refer to the election there. I was just trying to clarify, I'm not arguing that Rantoul somehow blew a 30-day period. I believe that when they did their redistricting when they passed that ordinance on September 9th, 2020, that was in excess of 30 days prior to the next election for them to elect officers, which would have been the 2021 election. So I believe that the Village of Rantoul satisfied strictly that requirement about redistricting. That doesn't change our argument at all. The other counterpoint I wanted to raise, though, is that Mr. Wilson has argued that the Dedonker case effectively overruled the Mason case. I don't believe that's the case. I believe that they are consistent to a certain extent, but that they actually examined different issues. So they are consistent to the effect that they both analyze the legislative intent the same way. And Mr. Wilson posed the question, well, so what about this? So what if they haven't had the ability to examine it for that amount of time? The issue is that the mere pendency of a petition to change the system of elections during that 4-year period does not provide the freedom from an obstructive, like tainting of the government in the meantime. So here, and it's exactly what the appellate court stated in the Mason case, the voters should be afforded the opportunity to function in a stable atmosphere such that the electorate can fairly determine whether it provides a form of government which is desirable. So you don't have a stable environment when there's another question pending to overturn it. And then what happens if this question goes on the ballot and then people circulate again another petition? I mean, this could be an endless cycle in Rantoul if we just are putting these questions on the ballot every 2.5 years. But the Donker doesn't expressly say that it overturned Mason. It doesn't imply that it did. In fact, it addresses completely a different issue, which is the issue of when does it become effective, when do you operate under there? And the other thing Mr. Wilson said, well, the General Assembly could have amended the language. They did, in fact, amend the language after the Donker case, 40 years later, but they did amend it to clarify that the municipal manager form doesn't start until you actually have a municipal manager.
And they didn't amend it with language like adopted.
Correct. Correct. So, extrapolating again the legislative intent from the manager statute, if the General Assembly amended that statute to say, well, that happens when you actually have the manager, this would have to happen when you actually have the people elected to represent by district. So we believe that both of those cases are consistent, that DeDonker didn't overturn Mason. Neither of them are really on point to this case, but they are instructive as to what an appellate court might do as far as the legislative intent in this matter. And finally, the issue about the electoral board composition, that was not raised before the electoral board, so it's not really appropriate here, but it's a little bit of an odd situation that we have with the law, because under the statute, electoral board members are not required to recuse themselves if they have an interest in the proceedings. We've argued for many years that the Code of Judicial Conduct should be applied to electoral board members, but really the only statutory basis for disqualification is if you are running in an office where there's another candidate running for the same office. But it doesn't actually address in Article 28, which is the article of the election code that addresses referenda, what you do when there's a referendum impacting a whole village, which might have implications on there. Our rules of professional conduct would say if we have an interest in proceeding, we should step back. The judicial rules say that, but there's nothing expressly in the election code, and no party filed a motion to disqualify the board members.
That's true, but let's just, if we're on the subject, I mean, they are a quasi-judicial entity. So if they're quasi-judicial, shouldn't they, Mr. Wilson would argue, be quasi-ethical with respect to conflicts of interest?
Well, I agree, but no party actually raised that before the board. And it looks like when you consider what the board's actions were, they tried to shift it to the county, and the county sent it back to the municipality. The board members could have all disqualified themselves because not only did the one trustee sign the petition, all of the members of the electoral board, and it's in the record, all of them signed the petition. So they all had an interest in it going forward. I don't know what the basis would be for the court to invalidate the composition of the electoral board, though. It's an interesting kind of intellectual issue, but there's not really a statutory mechanism to do that.
Well, it's not raised in front of the board, so I can only consider the record.
Exactly, but I did want to just comment as to how odd the law is with respect to that. That's another thing we probably need a legislative fix on in the statute. But other than that, we do believe that under the express language of the statute, combined with the guidance on the unrelated statute in both Mason and DeDonker, they all support the petitioners, for the petitioner's judicial review, not the underlying petition position.
Okay. All right. Thank you very much. And Ms. Kraft-Effer. All right. I want to take a few additional matters. First, I thank the lawyers in this case for their written submissions and thoughtful arguments and responses to my questions. Occasionally, people duck questions or run away from them, and I appreciate the way that both sides put them head on. So, I try not to hide the ball about the issues I think are interesting or concerning in a case. Now, next, there is the motion to stay the decision of the Electoral Board that was filed. I took it under advisement at the last hearing. I said I would rule on that later, because I believe I will be able to get a written decision issued in this case by the end of the day tomorrow. And I understand the position of the clerk to be, Mr. Bannock, you can assist me here, but essentially what I took from your, do you want to confer with the clerk? Okay, and I should have, I don't have my glasses on, Mr. Ammons. I meant no offense. I would have identified you as a party present. Mr. Ammons is seated just beyond my field of vision, but I see him now that Mr. Bannock is talking to him. Take all the time you need, Mr. Bannock.
Thank you, Your Honor.
May I go? One other thing is we do not agree with counsel's representation that all of the people who were involved on behalf of the petition to make this basically a recall of the abandonment. I don't think they all signed
Well,
the
it's not in the record, so you can make the point of clarification from your client's perspective, but
I think you have it, the record, Judge. I think the village has submitted a copy of the petition that was signed by everyone.
but the issue, the objection is not
I'm
raised.
sorry.
Right.
Well, if it was raised by counsel, that's beyond the record here, yes.
Okay. Well, let's. I'll make a note of your comments there, Mr. Wilson. Okay, Mr. Bannock, back to you.
Yes, Your Honor, thank you for that moment to confer. I have confirmed with the clerk, and a decision from Your Honor by the end of the day tomorrow would be great, and that meets with our necessities to do the work to prepare the ballots.
Okay. So, in other words, if the court can do its job, then the motion for a stay can be continued generally. In the unlikely event that I'm not able to do that, we'll have to call up the motion for stay on an emergency basis. But at this point, knock on wood, we should have a written decision by the end of the day tomorrow, and I understand the representation that will be sufficient time for the clerk to do or not do any action in response to the court's ruling. Okay, I believe that concludes the hearing today. Thank you again to everyone who attended. Thanks to the parties and lawyers. We will go off the record. Well, no, let's stay on the record for 1 minute. Mr. Wessner,
Almost
I
wanted to
forgot.
come back.
Yes,
to
you almost
Yes.
got out of here.
No, I
Without
and I would
more
have
work.
explained to the court, I will make every effort to try and get my stuff done before the end of the day today.
That was exactly the timeline I was going to impose upon you. But Mr. Wessner, let's make it official. The village then is ordered to file a corrected version of the record by the end of the day today. I understand that I've imposed insane timetables upon you, Mr. Wessner, but that's the nature of electoral disputes.
I'll manage my best, John.
Okay, all right, no offense is meant. With that, we'll go off the record. Thanks to everyone who participated.
Thank you.